Good morning, myself SOHAIB and my student ID is WHZ3012. Today me and my group is going to present a case study that is about Australian Security Investment Commission versus Cassimatis. So we choose this case because it's really beneficial to understand the application of duty of care. Now let's go through the slides so you will get better understanding of the case. First of all, duty of care. So the director of this company, who are the only shareholder of this company, they were actually failed to provide the duty of care. So they breached actually two sections, section 945A and section 180. I will give you a brief information about this section, but let's go through the other slides first. First of all, balanced decision. The decision from the court was pretty balanced because all of the allegations were not against the shareholders. Then the involvement of the financial institution. So actually, to make this case more complete, we add another case that was about storm scheme. So what was the storm scheme? So let me give you a brief introduction of storm scheme. So it was actually they were actually mutual financial institutions who are involved in a scandal. So basically they provide a scheme to the investors, so they allotted loans to the investors, then they provide them, they suggest them some specific banks to make their interest more. And when they actually got loan, they made them to invest in a cash pool that was also run by storm scheme. So later they invest this money in a share market through index. So this was pretty glittering scheme. Why it is glittering scheme? Because all of the investors were really happy about the investments because they were just getting loans, they were investing it, and they were paying all their expenses from the income they were generating by their investment. So basically they were not paying anything from their pockets. But all of the things were not running in their favor. Later on in the global economy, there was a sudden plummet of crisis, and this affected their investment and their market value. But the principal amount of loans were still constant. Then safeguard and the interest of investor, and then lead reaction. After all of these, ASIC came to an action. ASIC is Australian Security Investment Commission. They came into action, but due to their late reaction, people are talking about that ASIC was waiting to settle everything out of the court. And there was another point that, is there any case against the bank and financial institutions, especially against the Macquarie Bank and the Commonwealth Bank, because these two banks were allegedly partnered with the storm scheme investors. And now let me tell you the breaches that the director of this company have done. First of all, section 945I. Subject matter must be investigated in relation to investor. Not compliance. Storm directors had argument regarding compliance with this provision. They were of the view that studying the particular financial product, its performance, profitability, and prospective growth is sufficient to satisfy this provision. However, the directors failed to comply with the words in relation to. The second breach was financial expert must give advice which seems appropriate in the relevant personal circumstances of the investor. Storm failed to comply this requirement because there was a pool of investors involved who are old and reaching to their retirement, so they cannot actually afford any kind of loss. And the last breach is section 180. Since one of the class of the investor were those who were about to retire, the contravention of the third condition of the section 945A also calls for contravention of section 180 duty of care. The directors must have acted in the best interest of their investor. That's all from me for today, and thank you so much. And now my group member Jamil will present the further case. Thank you so much.
Thank you, sir, for calling me. My name is Jamil and my student ID is WHZ3007. And I'm going to present the critical analysis of court decisions. First, I would like to tell you some points which we have made in the presentation. It's The first one is specific focus on role of directors. It's that in order to keep the litigation narrowed, for the core issues, the precedent only covered the role directors and not for the officers. However, Section 180 of the Corporation Act provided an explicit role of the other officers, yet the court focused on the role of directors. This kept the investigation and questioning specific to the subject matter under the consideration. The next one is the private and the public duty. The court has been very bold to widen the scope of duty owed by the director, as SOHAIB already told you and discussed about the duty of the care. The directors continue with the plea that the case is the private duty, not of the public duty. However, the court turned this argument down and maintained that the duty owed by the directors was private as well as the public. So it wasn't just like the private or the public, so they just declared that it is a private and a public as well. So the term duty needed a delicate construction to resolve this private versus public, which was done after thorough screening of numerous cases law. So the next one is same directors and shareholders. It was submitted by the defendant that shareholders of the company were the only directors of the company. Therefore, there is no public breach. The grounds that were presented by the directors were categorically rejected by the court on the basis of 4 primary canons. The first one is the inconsistency of the submission, which means that the company violated the provision of Corporation Act, which cannot be validated by the shareholders. So the next one is the historical perspective. Many of the case laws listed above inter alia reveal that the fact that duty of director is a public duty and cannot be restricted to its employee only. Last but not the least one, it's unprincipled submission. It was submitted by the directors that they didn't commit any intentional offense. Therefore, the breach of the duty doesn't constitute. It was held by the court that intention is not a barometer to judge whether the breach is made or not. Duty of care exists at all of times. Last one is submission not supported by the authority. It was concluded that if directors act in the interest of shareholders themselves, it doesn't necessarily refer to a situation whereby interest of shareholders and company collaborate with each other. Directors are responsible for acting in interest of company and not for the shareholders alone. The next one is allegations for contraventions against Section 1041E. Australian Securities and Exchange Commission and Investment Commissions allege the Storm directors to have committed contraventions against Section 1041E. It was pleaded that the company has made false statement in order to market their products. The court being objective and just did by the this way and clearly rejected all these allegations. This indicated that the court have been over passionate to give a popular decision which is more titled towards the general public. They have tried to test each allegations against the principle of proportionality and equality. The next one is the benchmark precedent, which is the case of the Maxwell. Maxwell decision was principally relied upon the directors in this case. The honorable judges didn't rely on Maxwell decision in the decision of Storm directors. Maxwell was used by the defendants for proving that mere contraventions of Provision Corporations Act do not constitute the breach of the duty. The judges went against the principle, established that the interest of the organization was jeopardized, and set another precedent against the Maxwell decision. Although there are some charges against the banks as well, so it's been a landmark case which has opened doors for third parties who are not directly related to the transactions, that they must be punished as well. Because they have some faults as well. They didn't check properly what the case was and what the issue was. So there was already a case and settlement going on between the Macquarie Bank and surfers of the Storm scandal, as I've already explained about this Storm scandal. All of a sudden, when the settlement was about to arrive, Australian Securities and Investment Commission regulatory caretaking role and filed an appeal against the bank. The appeal claimed that not all of the parties have been given a chance of being heard, Therefore, the case should be reopened and all investors must accommodate in the case and must be provided compensation. The case was decided in favor of the Australian Securities and Investment Commission by the Federal Court. It must be noticed that the decision of the court against the director has been criticized harshly in many circles. As per the critics to the directors, the court has only held Storm as being liable. However, the role of the Australian Securities and Investment Commission was extremely dominant when the Storm was committing all this hasn't been pinpointed anywhere in the decision. As per our review, the global financial crisis erupted all of a sudden, which might not have Australian Securities and Investment Commission to sense its repercussions on companies like Storm. So at the end, I would like to give a short conclusion about all the case study and what we have done and what we have presented. So this case law has provided new dimensions to establish a duty of care. The critical element in the case was that directors and shareholders were the same. But honorable judges still uphold the provision of duty of care. There was no weightage given to the circumstances of the investors who were reaching their retirements. There has been a leverage given to the directors of the company in terms of the classification of offense. The offense has been taken as a civil, not as a criminal, which shows that the court has given consideration to almost all the factors that were necessary to be considered. That's all from our side, and that's all from our presentation. Thank you very much.